With that, I will now ask council to come forward on case 12338.
May it please the court. Again, my name is Jennifer Roth. I work at the Appellate Defender Office, and I'm here because I represent Alan Busch. Mr. Busch, I'm just jump right in. As the court pointed out, I know you're familiar with the facts, and what we're here on is pretty limited. Mr. Busch argued to the Court of Appeals that the state had the burden to prove that his New Jersey convictions from 24 to 34 years ago, his prior convictions, should be scored as person felonies, and that it failed to do so because they do not require proof of any of the circumstances in the applicable statute, which is 216811 E3 big B. Mr. Busch was not alone in this belief. The state agreed with him that the current record does not contain substantial competent evidence that would support treating these 5 New Jersey convictions as person crimes, and asked for the case to be remanded. Then the Court of Appeals agreed to extent with Mr. Busch that the New Jersey statutes cover conduct beyond the circumstances in E3. But nevertheless, the Court of Appeals found that the parenthetical notation of residential satisfied this on the pre-sentence investigation report, satisfied the state's burden, and found the New Jersey convictions were properly scored as person felonies. So that brings us here today on one issue, and that is whether the Court of Appeals decision violated the 6th Amendment when it concluded that this notation in the pre-sentence investigation report that said residential in parentheses meant that the district court properly scored Mr. Busch's 24 to 34-year-old New Jersey burglary and criminal trespass convictions as person felonies. I would actually suggest that maybe it's even easier than I originally thought as far as how this case is resolved. And that is merely through the language of E3B. We acknowledge that the test for how you score those out-of-state felony convictions is now different. There is a circumstances test, and what that test says is it lists out, and I guess I should back up and say, this wasn't in our petition, but I'm familiar with how we came to have this test. I'm familiar with some cases about it. So if the court has questions in that regard, I am prepared for that, hopefully. But we acknowledge that the test is different, but even under the statute as it is now written, which lists out a list of circumstances that if they're present in the elements of the other state's statute, then you score them as a person felony. But that whole test, the whole scheme of it is in 3 sections. And the final section of E3B tells us that any out-of-state conviction for the commission of a felony offense shall be classified as a non-person felony if the elements of the offense do not require proof of any of the circumstances in subparagraph B1 or 2. And that is what we have here. What we have is when we look at the New Jersey statutes that are in, I believe they're in the petition as well as the brief, that when we look at the circumstances and when we look at the New Jersey statutes and what burglary requires and what criminal trespass, what the elements of criminal trespass and the elements of burglary are, and when we look at the circumstances and when we look at E3B as a whole, we can see that the new elements of the New Jersey statutes do not require proof of any of the circumstances in the rest of that statute.
Counsel, is the use of the term circumstances suggest a factual inquiry or an elements test?
So I keep calling it the circumstances test because that's the word that's used, but essentially it is a list of elements. Yes, it's a list of elements. And I would say that because, well, I think that's what it needs to be, but I also think that that is what it is. And additionally, the proponents of that test wanted it to be constitutionally valid. They wanted it to be presumably easier. And so I believe that it is elements and not facts.
The defendant stipulated that he had a criminal history of A. How does that affect our analysis?
So the way the Court of Appeals looked at it is that my client did not actually do anything. His attorney, when the court said, do you agree you're an A? His attorney said, yes. And my client didn't object or agree personally to anything, which is why the Court of Appeals reached that issue, as opposed to saying you're out of here because you agreed. And so I believe that that is a difference. But even if this court sees otherwise, that somehow or another my client's lawyer answering for him, if the court sees otherwise, I don't think that Mr. Busch still prevails, because even if the burden somehow shifts to him, which I would go pretty close to saying that I can appreciate that. And if so, if the burden does shift to him, that he still prevails merely by looking at the New Jersey statutes and looking at what the current test is, and that he would meet his burden to show that those should not be scored as person felonies.
Is there a distinction between the criminal trespass and the burglary statute? That it seems like there is.
Yes.
The elements of the criminal trespass includes a dwelling
It's-
element,
Right.
which
So
seems to put it in a different analysis than the burglary, at least as I kind of look at the surface of this.
Right,
And
so-
I guess I don't have as much of a problem with categorizing the criminal trespass as satisfying the statute as opposed to the burglary.
right. And in our petition, we do acknowledge that to the extent that it still makes a difference, which I think it does, to the extent that it still makes a difference, that we are not allowed to engage in impermissible fact finding.
Right.
That the thing about the criminal trespass statute is that it is divisible in a way that the burglary one is not. And so I agree, Justice Rosen, that there is a means there's a way by which a person can commit criminal trespass that would involve a dwelling. So yes, so in that way, I still think that and I guess in a way, so does the state, that even when we are talking about the criminal trespass, that there was not substantial competent evidence to add residential in parentheses to that conviction. And furthermore, the only way to arrive at a parenthetical notation is to engage in impermissible fact finding. But actually I back that up because it's a divisible statute, then that's why I think it would be okay to send it back to have a court decide whether they can permissibly find that it is a conviction under the statute that talks about dwelling, or the subsection that talks about dwelling. Sorry. Okay.
So understanding of the New Jersey statute is that if the 1989 version was convicted offense under this subsection, the crime of the fourth degree, if it is committed in a dwelling, otherwise it is a disorderly person's offense. So why do we need to know anything more that it was a conviction for trespass and not a disorderly?
Why do we need to know? Because a disorder,
Just the label of the conviction, the PSI shows, I believe, that it is a criminal conviction of that would fall within that fourth degree of, so that we would know it was a dwelling, as opposed to not labeling it as a disorderly offense.
Bill? It is on the PSI as 18-3A. And in 3A, as the court just mentioned, there's different ways that you can commit the thing under A. And one is, if it's committed in a dwelling, otherwise is a disorderly person's offense, which under New Jersey law isn't even scorable or wouldn't be scorable in Kansas. So that's why I think it makes a difference, if I understand the question correctly, that even when you look at the statute cited in the journal entry, it says A, and A has these two ways. One way it wouldn't even be scorable, one way it could be a dwelling. If your question is, well, it says residential in parentheses, I would just point out, there's no word residential in 18-3A. There's no residential mentioned at all in the New Jersey statutes. They don't use that word. And so I would go back to this idea that there was not substantial competent evidence. We don't know how this parenthetical notation came to be, which even the state agrees that there wasn't substantial competent evidence to support that.
Does that matter if the meaning of structure in the New Jersey statute includes residences?
Right. Do you mean with regard to the burglary and the criminal trespass, or
Well,
just the criminal trespass?
Let's just talk about the burglary, I guess.
I think that it does matter. And that is because if this court, it's like I was saying at the beginning, the circumstances test is there in E3B, and that has 3 different subparts, as I recall, which I am sorry, I didn't put that one in my petition, but it's in my brief. But that test has I, which lists out the circumstances. It has double I, and then it has the triple I, which is where the whole statute ends and refers back to I and double I by saying that if the out-of-state conviction shall be classified as a non-person felony if the elements of the offense do not require proof of any of the circumstances in B, I, or double I. And so that's why it matters. When this court is, I think it's safe to say, big on looking at statutes. I'm afraid I'm going to mess this phrase up, but in pari materia. And so this court is big on that. And so I doubt that this court would approve of us just reading I and stopping there.
Does the statute contradict itself? Because the language the Court of Appeals relied on is not the language you're talking about in the statute, right?
Right.
That's the language that says we have a phrasing in the negative and then we have a phrasing in the positive, right? Sounds to me like your argument is essentially that those two provisions conflict with each other, because the positive phrasing says if one of these circumstances is covered by the out-of-state statute, it is a person felony. Am I
Yes.
reading this wrong? Or?
Yes, no, I think that you're right. The reason, I guess that I didn't think about them conflicting and just always thought about, I don't know if it's triple I don't know how you would refer to that subject. At any rate, is because I know what the intent of this was. And so when one looks at which I'll admit is not in the petition, but when we look at what the intent of this was not the original Wettrick fix that was proposed to the legislature in 2019. And instead, a group of prosecutors put forward this circumstances test. And in so doing, they said, both to the House and the Senate, that we believe it's the stated policy of the state of Kansas that a prior out-of-state felony that necessarily requires proof of any of the following should be treated as a person felony. And so I never thought about them contradicting until basically recently. And so to the extent that we think that I and triple I conflict, when we read that statute as a whole, we believe Mr. Busch prevails, that you do not necessarily have to prove any of those circumstances to find New Jersey burglary.
I have one last follow-up to focus on the Court of Appeals reasoning on this question. And at the bottom of page 6, top of page 7, the Court of Appeals says basically Kansas recognizes burglaries of residences as person felonies. And then they say on the face of the New Jersey statute, Busch was convicted of an offense that encompasses both residential and non-residential structures. That seems to me to be a logical way to read little I in the statute. Would you agree with that? And I understand you say, well, wait a second, look at triple I, but
Right. I'm going to look at page 6 really fast. Right. So you're saying that if I just read I by itself.
right.
And it says residence and structures by whatever have to require that. I have to say, you're not wrong.
Yeah,
I mean.
it does seem like there's a,
It's right. I mean,
there's a
where
contradiction.
else is it dealing with a structure? But again, I go back to this, number one, what the intent of the offers were that was then adopted by the legislature in adopting this test, and also what it says in 3.
So just to put us in our statutory construction framework, it strikes me that in the course of our conversation over the last few minutes, if we're right in our discussion, at a minimum, this creates an ambiguity in the statute. Would you agree with that?
Yes.
Thank you.
Yes, and, yes. Sorry, I see I'm out of time.
I have a question, if I may. Criminal trespass statute, going to Justice Luker, does include residents. But then it depends on the level of severity it is, whether it's disorderly or level 4. Would it be appropriate for the district court to look at the sentencing journal entry, determine what sentence the defendant received in order to determine, without fact finding, whether it was disorderly or a level 4?
That is interesting. I hadn't thought about that. I mean, it says that in certain situations, we can look at certain documents. And again, as I was talking earlier, I have to admit that criminal trespass is a divisible statute, where you could look to these other documents. So I guess my gut reaction is that seems like something one could do.
But that wasn't done at the district court.
Oh, no, no.
Questions?
Please, the court, Kelly would like to start with the Court of Appeals addressed, and also acknowledging that the appellee feels both the appellant and appellee, really because of this circumstance with this whole debate since Apprendi arose and Discamps, all the way up through Wettrick with here in Kansas, been arguing a lot of this for a long time. So the state was used, or the appellee was used to the fact that you have to have this brand new pile of information that you obtain from the other states and the other cases to make where a person's criminal history falls. And counsel also appreciates that the appellant recognizes that appellant seemed to argue in the brief that we needed to stay with or go back to the comparison test without really ever acknowledging we now have a circumstances test statute. But here today, there needs to be a lot more focus or an understanding that we have the statute. But I would like to start with the Court of Appeals decision. Substantial competent evidence is that which possesses both relevance and substance and provides a substantial basis of fact from which the issues can reasonably be determined. State feels the Court of Appeals rightfully pointed out the factual circumstances that existed at the time of sentencing. One of the things the Court of Appeals pointed out that very relevant is the PSI wasn't just presented with topics and items that are statutorily required to be in it. That notation of residential was included with it. So with no objection by the defendant or his counsel, the PSI being presented and accepted by the court, the court having the additional notation of residential on each of those, the state feels that in that circumstance, without an objection, that rises to substantial competent evidence. So we feel that the Court of Appeals did properly analyze that issue.
But even if you assume that, why does it matter if the only thing you look at are the elements of the crime?
That's the second part of the argument, which is the real reason the Pelley feels we're probably here today, is it's our position that with the new statute, you only look at the circumstance of whether under 216811 at a residential dwelling in this circumstance. And if we follow the appellant's line of reasoning, we end up going back to the pre-2019 statute in that regard, basically with the old test that we originally had. But it's obvious the legislature intended to create a new set of standards that we go by.
Well, so let's talk about the statute. I'm gonna quote from the statute. An out-of-state conviction shall be classified as a person felony if one or more of the following circumstances is present, and here's as defined by the convicting jurisdiction in the elements of the out-of-state offense. So that's the new statute, as defined by the convicting jurisdiction in the elements of the out-of-state offense. And then when you get to H, it's entering or remaining within any residence, dwelling, or habitation. So if the out-of-state statutes include entering or remaining within any residence, dwelling, or habitation as an element, then it's a person crime. If entering or remaining within a residence, dwelling, or habitation is not an element of the out-of-state statute, then it's a non-person crime. Would you agree with my interpretation of the plain language of the statute?
Not willingly.
Okay, so
I-
where
I-
is my analysis of the plain language of the new statute at 216811E3B? Where am I flawed?
I think the intent of the legislature is.
But we're not getting to intent. I'm talking about plain language, inserting the language. We're not getting into any, I mean, the intent is reflected by the plain language, except as, unless there's an ambiguity is.
And Your Honor, if you're suggesting that you look at the elements to see if that particular subsection of the statute is met, then I would say you still look at the elements, but I don't think you go through the comparison with particular statute that we have in each state to determine whether that
Then what does this language mean?
subsection met.
But then what does this language mean? It says, as defined by the convicting jurisdiction in the elements of the out-of-state offense.
I think what that means is you still look at that jurisdiction's statute and at the elements of the crime, but you don't ask, do we have a comparative crime in Kansas with all the elements? Do we just have a meeting of that particular subsection by looking at that element?
Right, we look at the circumstances with the colon, which is under subsection H. Okay, we look at the out-of-state elements of the out-of-state offense and compare it to subsection H, which is in the out-of-state offense. Do you have an element of entering or remaining within any residence, dwelling, or habitation. So instead of comparing it to any statute that we have, the legislature said, here's H, right? So my question to you is, does the out-of-state statute include entering or remaining within any residence, dwelling, or habitation?
I think the trespass statute sets that out better than the burglary statute for New Jersey. But regard to the bare bones statement of the statute, I would have to acknowledge it does not.
Well, let me ask a follow-up. Why wouldn't the New Jersey's use of the word structure and then subsequent definition of structure in their definitional sections include entering into a residence? And why isn't that the element? That's what the Court of Appeals said. The Court of Appeals said, this New Jersey statute includes this element. They don't use the precise exact words, but when we look at structure and we look at the definition of structure, we can say, this is the element that Justice Standridge is referring to under subsection H.
Here, I'm a little.
Why is that
slow.
wrong?
I'm considering where we were before 2168-11 was passed versus now. If Billy feels that the Court of Appeals can still interpret that way and is correct to do it that way. Historically, though, we were comparing the element and right down to the words in our.
It just sounded,
statutes.
maybe I misunderstood, but it sounded like you just sort of conceded that the Court of Appeals was wrong in their analysis.
Well, I didn't mean to.
Well, let me ask my follow-up. Let's assume for purposes of my question that Court of Appeals analysis of subsection, and there's a lot of subsections in the statute, so it's confusing, but where we're at is BI, single I. That's the subsection the Court of Appeals was focused on. Let's assume they were correct in their interpretation. I want to go back to my discussion that I had with your opposing counsel, which is if you look at B triple I, it looks like the statute says exactly the opposite thing. And isn't there just a plain contradiction there? Because what B triple I says is that it shall be scored as a non-person felony if the elements do not require proof of the circumstance. And that's clearly the case here because structure is broader than residence.
Your Honor, way I would look at it is, I don't necessarily see it a conflict because I consider the first subsection to be more specific in nature, to a very specific statement of what applies in that circumstance, and the second section to be more general. So I would believe that we would have the circumstances, if you can meet it statutorily, you can rely on the habitation or dwelling part of the statute instead of the second part. If you don't necessarily have a clear rendering in that situation, Your Honor, you asked whether of other counsel, can you go back to the sentencing journal? State would believe that it would be. Look at the sentencing journal entry because it would not be adding facts from a crime or the event that occurred, but you would merely be looking at the classification it received. So the state doesn't believe that would violate.
Does the state have the burden statute that says the state should put forth or submit the journal entries, right?
If there's a filings of the PSI, state's being as a substantial competent evidence of the criminal history that section what to do.
Did the district court advise the defendant that he had a right to a jury trial on residence finding?
Yeah, at the time of sentencing, no.
That matter?
Well, properly set out in the briefs, well, and in the Court of Appeals decision too, it acknowledges that the right to objection or concern is the defendant's, not his attorney. So,
Did he admit? Your opposing counsel said he merely acquiesced.
counsel admitted, defendant.
Counsel, if I can, I want to make sure I understand your position on the New Jersey burglary statute. Do you agree that the elements of burglary in New Jersey do not necessarily require proof that a defendant entered or remained within a residence?
I have a question. 21-6814, which sets forth the process for establishing a criminal history, an offender's criminal history in court, which you referenced a few minutes ago. The state has the burden to prove the criminal history, and you said if the offender doesn't object, then it's substantial competent evidence. But in 2022, the legislature added subsection D, which talks about if an offender raises a challenge to criminal history for the first time on appeal, that the offender can do that and designate a record on appeal that shows prejudicial error, which means that the offender could provide the journal entry on appeal. Does subsection D apply here? Or maybe you're not familiar with, I may be catching you off guard. I don't know. The last legislative session, 2022.
It would be the state's position. It does not apply in this circumstance. Thank you for your time. Nice to be here in person.
First things that my colleague here mentioned started was that, in a way, my brief, like, well, it's not comparability, it's this other test. And I will admit that when I was preparing for this argument, I was looking at my brief and my petition thinking, okay, maybe I'm confused about what the test is. Maybe I'm confused about what we can still rely on, what we can't. And so I just bring that up as an example of why we need this court's guidance about how we are to consider this statute.
Counsel, along those lines, would you agree or disagree with the notion that one of the overall purposes of the legislature's redrafting of this is to get us completely away from delving into the underlying facts of an out of state conviction because of all the problems that are associated with that?
I would agree that the offers of this and the legislature adopted that they want to try and get away from that.
In other words,
Yes.
this statute is crafted as a matter of law test. No need to delve into the underlying facts of an out of state conviction. At least that's the intent.
But We can call them circumstances rather than elements. The fact is that you still, even using this test, you have to look at the circumstances and compare them to the out-of-state, the out-of-state priors elements. And
Right.
so I can appreciate that we are trying to make it simpler. I don't know that that's what happened, but this idea that we can somehow, that it's going to be like a super quick process, that's just not how it is. You still have to look at the out of state. So I guess I'm still agreeing with you, I think, but I'm trying to explain that it's not as simple as some would make out, I think.
Because we
would-
still have a situation where even if that's the intent of the statute and we do want to streamline it, you still have to protect the defendant's right. Because if you have a statute that's broader, that could encompass, that defines structure as, a place that could be inhabited, but it's also a warehouse or it's a, tent or, or whatever it is, that, that there is the problem that it could be broader and sweep someone under, right? I mean, that still applies regardless, right?
Exactly. And in fact, if
I'm sorry to interrupt, but why does that apply? And this gets to the constitutional question, right?
Right.
Why couldn't the legislature just write it out, just say under New Jersey, code XYZ, it's a person felony? Why did?
they could do that.
So
In
there's no
fact-
constitutional infirmity that just because it's broader, we're only talking about how to score it.
In theory, there's different ways that the legislature could just say, well, you commit anything out of state, you can't do that. Can you? Right. Like, could they just say, well, everything's a person felony, or if you have an out of state conviction, we're going to tack on X number of months, but.
Couldn't
but
they do that?
You can't because we do still believe, or it's our position that these constitutional concerns still come
But
into play.
what would
No,
be the
but-
constitutional concern with the legislature simply saying, there's no such thing as a non-person felony anymore? They're all person felonies. Why couldn't they do that? It would be maybe an outrageous policy, but where's the constitutional problem?
Well, I think that what comes to mind is the problems that are discussed in things like DeComp and Mathis, which I'm gonna
that
admit, I'm
has to
not
do
as
with-
smart as other people. on this. Sorry.
Okay, but I think Justice Stiegel is right, but that's not the statute we have here, right?
Right, thank you. Right, what they chose, they could have left the test electric. But.
They could have said, as Justice Stiegel says, they could have said, you commit something out of state, it's a person felony. Our legislature, but that's not what they did,
Is not
right?
what they said. And so what we are left with is something that I would argue does require some degree of notice or whatever. But more importantly, when we are talking about the intention of the legislature and what this statute does, one of the reasons put forward by the proponents of this test was that to address, they wanted to, well, let me back up. It's really what we're talking about here is what you all said in Wettrick, that this concern that you are not sure who to include. Are we including people we shouldn't? And the ramifications of that, that's what's happening here. So if the idea was to undo that and not have that happen with this new test, it's not working because it will sweep in people that should not be swept in.
Let me ask you a question that I asked opposing counsel. Are you familiar with the addition of subsection D?
Yes.
Okay, so does it apply here?
So I thought about it a little bit, and I think that arguably if I had to go back, which I don't think I should have to, but in theory, let's say that this court says, all right, well, you can go back and argue about it below. Or let me put it this way. Sorry, I should have thought before I opened my mouth. In this particular, I think that it could apply. I also think that in this particular instance, for me to meet that burden, I don't need to produce any journal entries because on the face of this test and the face of the New Jersey statute, he wins. is my position, that Mr. Busch prevails. And it doesn't matter that we don't actually look at,
But you conceded with Justice Stiegel that there's an ambiguity here and that, you know, that structure as defined in New Jersey could include a dwelling. So the question is, did it include a dwelling? And this could be easily rectified had you just gotten the journal entry. I mean, do you automatically lose under subsection D?
no, and this is why I was answering D without even thinking about the other part. Because if the question, I was looking at it from if I'm bringing this up for the first time, well, they're work in conjunction, really. And the way that I see them working in conjunction is, if I'm bringing this up for the first time, which I am, then I have this burden. And what I'm saying is, I think I can meet that burden just using what I think the outcome should be about the test part, in that you, by looking at what does New Jersey necessarily require doesn't match the circumstances test. So I guess my point is, I think Mr. Busch prevails without producing any journal entries, and that it's actually problematic to bring in journal entries because of this idea of impermissible fact finding,
So
at least with regard to the burglaries.
I can't make a dwelling into a house, or I can't make a structure into a residence without facts. Elements test precludes me from using facts. Therefore, you win, right?
Right. Right. And I admit it's confusing because we're supposed to be having this new test, but it still requires us to look at things. And when we look at things, I believe he prevails, because what is required of the New Jersey burglary is not they do not necessarily have to prove one of those things in the test.
And that's triple I. I mean, and I think everyone's conceded. This might be the clearest point of this whole case. Under triple I, this is not a person felony. If we just look at triple I, and doesn't that just, I mean, from your point of view, it would seem to me, you would say case over. As a matter of law, this sentence does not conform to the statute, therefore it's illegal.
Right. And that is what I finally came down to last night, which is, this is simpler than I thought. Because if I agree, we have to say that the statute's ambiguous, and which triggers certain things for Mr. Busch. But yeah, it seems that it's easier than I thought. If it comes down that triple I controls, but has to be construed in his favor, we're done.
I can connect those dots on the burglary.
Right. And I do sort of speak of them as, you know, grouped together, but back to what Justice Rosen and you too, Chief Justice, were talking about, I will, and Justice Wilson, that I will admit that the criminal trespass part is trickier because it does use the word dwelling. And I hadn't thought about the fact that the sentence could tell us something about which one that was. But as far as burglary, I just feel like we're done if. And at any rate, if there are any, may I wrap, Chief Justice, may I wrap? Okay. At any rate, I would just ask this court to, I think our whole state desperately needs to hear from this court about what the statute means, how it works. And we would ask that you rule in Mr. Busch's favor. I think I put Justice.
Like he was ready to ask a question.
Only is a very technical one. If we rule in your favor on the burglary criminal history, but not in your favor on trespass, does that change the scoring?
That's right. And I thought about that, and the answer, I believe, is that it goes to being a B, because he had one, so there's one trespass.
So it's not moot, in other words.
It's not, no.
Would make a difference for your client.
I believe he'd become a B from being an A.
All right. Thank you.
Thank you.
Thank you to both counsel for your arguments. Court will take this matter under advisement